I'm Tom Bayless. I'm here with Chancellor Grover Brown. We're here to talk about the Weinberger case. Uh, Before turning to the litigation, uh, could you describe your practice until you joined the court?
My practice until I joined the court. Well, I was admitted to the bar of the state of Delaware in 1961, and I spent the first 2 or 3 years working with my brother, who was a lawyer. Herman Brown was his name. He was a lawyer, had a little office on the Green in Dover, and I don't know, I got a little tired of that and decided I'd be better off if I was on my own. So I went down the block and rented an office and began practicing law by myself about 1963 or 64, I guess, which I did for 7 or 8 years and found it very enjoyable, except I didn't make much money.
So that's when you became a judge.
Well, not because of that, but it was a small town practice in those days. I think when I got admitted, I'm a native of Harrington, Delaware, if I should bring that in. But so I was born in Delaware, and when I got admitted to the bar in Dover, I think I was the 15th lawyer in town back then. And of the 15, 5 or 6 of them were old guys that had been around that were just sitting, counting their money and that sort of thing. And so I was fortunate that it was a good opportunity, because when there weren't many lawyers in town, particularly who went to court, you got a lot of chance to go to court, because in those days there was no public defender, and anytime a person was brought in and charged with a felony and was asked by the judge, do you want counsel because they have no money, and they said yes, I got a lot of those appointments. And that always happened in first and third Fridays of every month in those days, in the Superior Court was criminal arraignments and divorces and that sort of thing. And so you had to go over for the criminal arraignments because you generally had somebody. But in the old courthouse down in Kent County, there's big pillars, 2 big pillars that are around the council table. And I used to try and hide behind the pillar. I'd sit so I'd have the pillar between me and the judge. But it didn't work because the judge knew I was there, and every now and then somebody would say they needed a lawyer, and Judge Story or somebody would look around and say, Mr. Brown set you behind the post, and yes, Your Honor, I'm appointing you to represent this man. And so, it was good. In hindsight, it was a very good experience, because you got to go into court, you dealt with the judges, you had to know what you were doing, and nobody showed me. My brother didn't have time to do that. He was too busy doing other things, and he was of the view that if I tell you how to do something, you won't remember it. If you want to know how to do it, you go figure it out yourself. If I went to him and said, what is this writ of sci-fascius or something in the sheriff's office, he said, you go find out. So I think that's because he just didn't want to be bothered, but nonetheless, it was a good experience. And so I guess for about 10 years, I spent a lot of time in court, and not on major cases, but on felony cases and things of that nature. Tried a few jury trials. Nobody showed me how to do a jury trial. You just had to go in there and figure out everything yourself. But I'd grown up in that kind of an environment because my parents died just before my 10th birthday, and I grew up on my own, so I was used to doing that. I spent 6th and 7th grade in the military academy, Chatham, Virginia. Got up to the bugle, learned how to salute and do all those things, do what you're told, make your bed, shine your shoes, And that was probably not the best thing for somebody in the 6th and 7th grade, but in hindsight, it was very beneficial. So,
Perfect training for a future star on the bench.
No, I don't know about that, but you learn to do what you were told and what you had to do, or you'd pay the consequences, So.
How did you end up joining the bench?
Well, as I told you previously, basically by default, I was practicing by myself in my little office next to the theater there at Dover, and I was initially asked at some point to become a judge on the family court. It was a juvenile court, I think, in those days, but I forget who the governor was, but they needed somebody to appoint the family court judge who'd been there for years and who I'd spent many days with, retired. And under the way the Delaware judicial system was set up under the Constitution back then, you always had to have a balance of Republicans and Democrats on the courts. And they had a need for a Republican. I'm a registered Republican. I have nothing in common with Republicans. I just never wanted to be a Democrat. Because in Harrington, where I grew up, the whole town was Democrat, basically. And I wasn't a joiner, and my brother was a Republican, and he gave me a job to start with, so I thought I'd better register Republican. So, as a result of that, they were looking for a pigeon who was a Republican to be a family court judge, because nobody really wanted to do that. And I said, no, I don't want to do it either. So I turned it down. They got somebody else, a young attorney, Roger Kelsey. And then later they enlarged the family court, added 2 judges. They added, whatever they added, there was an extra judge added downstate. Because in those days there was 1 in Kent County and 1 in Sussex County. And they needed a third. And then governor sent people to get after me again, and I got to thinking about it. I thought, well, I don't know that I want to do this, because I'd spent a lot of time in the family court defending all sorts of things. And it wasn't what I particularly wanted to do, but I thought, you know, I'm here by myself. I don't make a lot of money. I enjoy it. I was married. I had a little girl. And I thought, this doesn't make much sense. I think, you know, back in those days, it paid $27,000 a year, which wasn't bad back then. And I thought, I'd better take this, because if something happens to me and I die, at least, you know, there's a pension, take care of my wife and daughter and that sort of thing. And I thought if I don't like it, I can always quit. So I became a family court judge.
How did you end up on Chancery?
Well, I was on the family court for, what, I guess 3 years, 2 years, something like that. Any event, it wasn't what I really wanted to do, because, as I said, I was a third judge, a swing judge downstate. And there was a chief judge in Kent County and a chief judge in Sussex County, and I was the guy in between, so I had to run back and forth between the counties. And, you know, got most of the crappy jobs because, you know, rank has its privileges. And I'd done this for a while, and then I got to thinking, you know, I don't think this is what I went to law school for, because I never wanted to do it in the first place. But I didn't know how to get out of it, because I didn't have a practice I could go back to. And in those days in Kent County, all the lawyers were sole practitioners, except for a couple. There was no firms as such. And there came an opening on the Court of Chancery, which I actually knew nothing about, other than I was a great admirer of Collins Seitz. Because along the way, I had also acted as a deputy attorney general for the state. The attorney general back then was a fellow named Dave Buxton, and I knew him, and he got a hold of me and made me his administrative assistant, and which meant I answered his mail, basically. But because of that, I used to have to sit in on the Board of Pardons when it met monthly, and Chancellor Seitz was also by the Constitution on the Board of Pardons, and I used to sit next to the Chancellor, and I had great admiration for him. He was really a fine gentleman. But in any event, there became a vacancy because the downstate Vice Chancellor, Isaac Short, his term was up, and Ike, as everybody called him, not to his face, of course, but he didn't want to be reappointed. He'd had enough. And so you needed a downstate Vice Chancellor, who, in the constitutional scheme of politics, had, again, to be a Republican. Ike was a Republican, so you had to replace him with a Republican. And it was Sussex County's position, because he was Sussex County. And in the years before that, they had knocked down the old courthouse in Georgetown and put up the new one right on the circle, and had nice quarters and that sort of thing. But they still needed a Republican from Sussex County. And in those days, people were coming over from Washington and Baltimore to the beaches and that sort of thing, and all the attorneys in Georgetown, there weren't that many, probably only 20-some, they were all making good money on real estate settlements and that. And nobody wanted to give up what they were doing, become a vice chancellor for $28,000 a year, whatever it paid. And so, but it was their position. They had dibs on it because they had the office, they had the facility, and they had the retiree. But they couldn't find a candidate. Nobody was interested. So the Sussex County Bar Association met and ended up drafting one of their members who was not there at the meeting to defend himself, but they drafted him as their candidate, and his name was Jackson Dunlap, J. Dunlap. Nice guy, kind of practiced by himself. And I knew Jay because his wife was a cousin of mine. I gave her away at the wedding because her father was dead. But they drafted Jay. And I simply told the fellows in Kent County, I said, you know, there's 2 or 3 lawyers in town that if they're interested in this position, they should have it. But if you can't find a candidate, you're desperate for somebody, throw my name in. And so that's how it turned out. Nobody in Kent County wanted to bother with it either. And so that caused a big problem because the corporate bar up in Wilmington, which I knew nothing about at the time, I guess was horrified at the prospect that the 3rd member of the Court of Chancery was going to be one of these 2 yokels from downstate. One's a family court judge, and the other's a some small-time practitioner, never been in Court of Chancery in his life. And so they imposed upon the governor to they had a committee of I would say corporate lawyers. I assume they were all corporate, 8 or 10 of them, but they wanted to interview us, see who they could stomach, I guess, of the 2, because that's all they had. And so that was set up for interviews in Dover. Jay's was supposed to be at 10 o'clock and mine was at 11. When I originally heard that, I told my brother, I said, those silk stocking bastards up in Wilmington, tell them go to hell. None of them ever set foot in the family court. I got to go sit down and be interviewed by this gang. I'm not of their number. And he said, now, don't be hasty. And so I agreed to be interviewed. So the day the interviews came, and I was sitting in my office in the family court in Dover waiting for my 11 o'clock appointment when Wesley Atkins, who was the bailiff for the Supreme Court for many years, quite a fellow, he came knocking at the door and said, Mr. Brown, they're waiting for you. And I said, well, my appointment's not until 11. Mr. Dunlap's at 10. He said, Mr. Dunlap withdrew. And I was all they had left. So I went over and got interviewed and was asked questions and that sort of thing. And as a result, the downstate bar had no other choice, I guess, and thereby did I become a member of the Court of Chancery. But the price I had to pay was I lived in Dover, but the office was in Georgetown. And so that's what I did as a member of the Court of Chancery for all those years. I had to drive down to Georgetown every day, where my secretary was, where I could do anything, or I had to go to Wilmington, where most of the activity was. And but that was all right. I was younger then. I could do it. I wouldn't do it now.
What sort of training did you have in corporate law when you joined the Court of Chancery?
None. I didn't know anything about it. I formed mom and pop corporations for people that had a little business or something, where you send away for a corporation kit and get some stock certificates and a seal and draw up the minutes and all that. But that was it. And I figured, you have to learn it, I guess.
Did you have a law clerk?
No, I never had a law clerk in the Court of Chancery, whatever it was, 12 years. We didn't have it in the budget. In the budget in those days, there was only money for 2 law clerks. And the structure of the court, there were a chancellor and 2 vice chancellors. There was only 13 people, I think, on the Court of Chancery all the time I was on it. And there was the chancellor and 2 vice chancellors. They each had a secretary, that was 6. And there were 2 court reporters, that was 8. They each had a stenographer, that was 10. And they had a receptionist in the Wilmington office, that was 11. And they had 2 law clerks, that was 13. That was the court when I was on it.
How did you
There wasn't one for downstate because the 2 law clerks quite naturally came up for Wilmington. There happened to be a chancellor and a vice chancellor in Wilmington. And in the start, I didn't know what you're supposed to do with a law clerk, because, you know, I was never qualified to be one. I didn't know anything about it. But I asked them to do a couple things every now and then for me, and they'd say, well, you know, Vice Chancellor, we're glad to get to it just as soon as we get finished working on this thing for the Chancellor and this, that, and the other. And I remember one time I asked one of the law clerks up there if they could help me out on something, and he brought me in a stack of cases that he photocopied about 2 inches high and had done his job. And I said, oh, the hell with this. This isn't worth messing with. I'll just do it myself. So I never bothered to try and get a law clerk. I wouldn't have known what to do. It had just been somebody underfoot. And
So you joined the Court of Chancery in 1973, right?
that sounds right. Yeah.
And the Weinberger litigation gets filed in 1978. So you'd been on the bench approximately 5 years at that point.
Mm-hmm.
By that point, did you have a lot of training in corporate law?
Quite a bit. You couldn't help it back in those days. The corporate cases came in. I can't remember how many, but it wasn't anything new. I mean, a case like the Weinberger case, there were others. I lose track of time of when various cases came in, but there was a lot of corporate litigation. And I was fortunate because I had the benefit of very good attorneys in those days. And I'm talking about the Wilmington attorneys, not necessarily the guys from New York that they were, you know, local counsel for, but the lawyers were very good. They helped educate me. The briefs were good, the arguments were good, and if you paid attention, you could learn something.
The initial complaint in the Weinberger case gets filed on July 5th, 1978. It's 7 pages long. And in a later opinion, you wrote about it, to view this as pleading conclusions is to recognize the obvious. Under the decision of Singer versus Magnavox Co., however, this appears to be sufficient to state a cause of action and to require the court to hold a fairness hearing. Could you tell us a little bit about Singer and what you were referring to there?
Well, Singer was one of those earlier corporate cases that you were talking about. Did I have any of them? And that had come in. That was my case. And that was where, I guess it was North American Phillips, big company, had decided to acquire Magnavox, and had enough shares, accumulated enough shares, I forget how, but it had more than 50%, so, and they decided to simply cash out the minority shareholder through a merger. And they had a subsidiary and merged Magnavox into the subsidiary, with Magnavox being the surviving corporation, and put it out to the voters, which was approved. There was no problem, but it went up on appeal. Well, in front of me, the argument was, various arguments were made. I can't remember what, but I issued a decision and say, well, that's what the statute says. It says, the corporate law says if you have, you know, majority voting control, you can use it. And I couldn't find anything really terribly wrong on the facts of the case with what Magnavox had done, but it was appealed, and the Supreme Court reversed, and I think fair to say established some new law, and came forth with, and maybe it was deserved, quite frankly, but they came down with a decision that said it's a violation of your fiduciary duty as a majority shareholder if you use that position to merge out the minority for cash with no proper purpose. Maybe proper is not the right adjective, but without business purpose or something. And there was none there in the facts of this case, so they reversed and sent it back for trial. And I think it eventually settled. I never had to end up trying the case, but when Weinberger came along, the complaint that came in was basically what Singer authorized. The plaintiff simply said that Signal Company, or whatever Signal's, the rest of Signal is, I don't remember now, but that was the majority shareholder. and they had owned 50.5% of the stock of UOP and had merged out the minority for cash. And the complaint said this happened and there was no business purpose. So it didn't take many pages to get that.
So you were dealing with a legal regime where a 7-page complaint could survive.
Yep. I mean, yes, excuse me. I should talk more like a judge. Yes.
You also described the complaint as, quote, a document perhaps artfully drafted as such, possessing certain chameleon-like characteristics which enable it to change its appearance while under scrutiny of attack. It's a colorful metaphor. What were you describing there?
I'm not sure I remember exactly now in a degree, but it just, I think it's because there was nothing in it, as I remember. It was basically just, there was no business purpose for this. There weren't any allegations of fraud or misrepresentation or anything dastardly done by Signal. Just that Signal had no business purpose. And under SIGR, that's a violation of fiduciary duty. And, you know, give us our damages, Your Honor. So, you know, that meant that you had a lot of leeway to play with, I guess, if something went wrong. If that complaint got thrown out, you could, as later happened, I think you could modify it, add something, but wasn't anything of any great consequences, I recall, in that complaint.
You did end up dismissing the complaint, but then allowing leave to replead. Could you say a little bit about the decision to dismiss it?
Well, the reason was the way the merger was structured. Signal was apparently, through counsel, crafty enough to see that they had a potential problem under Singer if they just came in and used their majority share, 50.5%, not even 51%, to cash out the other 49.5%. And so the merger was structured under the merger agreement that before this could happen, it required a majority, I think I got this right, tell me if I'm wrong, but a majority of the minority shareholders voting on the merger. That had to occur, number one. And number two, if there was a majority of the minority shareholders voting, that number of shares that voted, coupled with Signal's share, had to represent 2/3 of all the outstanding stock of UOP. And so I thought, well, that's not what happened. That's not the problem Singer was addressing. Singer was addressing where you just use the numbers. I got 51%, we're cashing you out. You got to have a business purpose for that. But on this one, Signal didn't do that. They left it up to the minority shareholders to a degree. In other words, it didn't use its controlling position to put it through. There was always a chance that shareholders could have turned it down. I'm sure they weren't worried about it given the price they were offering. But at least it was tactfully structured that way. And so I thought this complaint that says nothing other than there's no business purpose doesn't pass muster, so threw it out. But it seemed to me under the circumstances I ought to be realistic. And since we were all dealing kind of in new ground, lawyers as well as the court, give them the opportunity to file an amended complaint. It was a big company. There was, what 11 million shareholders or something. I mean, it was a large company, a lot of people involved, and it seemed to me a lot of time had been put in it. And it just seemed to me that they ought to have the opportunity to file an amended complaint. So.
Let's talk for a moment about Mr. Weinberger, the plaintiff. In a class certification opinion, you acknowledged that he was 81 years of age. You went on to describe how at his deposition he had virtually no accurate knowledge of the status of the suit, that he was unaware of the findings and opinions of any financial analyst who'd been retained by his counsel. He hadn't met his lead Delaware counsel until 2 days before his deposition. He had virtually no recall whatsoever as to the outcome of several other class and derivative actions in which he participated as a party plaintiff, including one in this court in which I granted his motion to intervene as a party plaintiff, and as to which I approved a final settlement as recently as January 19, 1978. But notwithstanding that, you certified him as a representative plaintiff. Why?
Well, as a practical matter, you got to understand where I came from downstate, just common sense. If you throw him out, somebody else is going to come in anyway. They're going to put somebody else in. And actually, the lawyers ran these class actions. The named plaintiff, in my experience, and I think everybody else's, did virtually nothing except lend their name as stockholders. They qualified as the party to bring the suit. And it was always counsel that ran it, did things. And as far as I was concerned, it's why are we going to make a big deal out of Bill Weinberger? Doesn't know anything about the case. He's not the first class action plaintiff or derivative plaintiff that's come through here and doesn't know a damn thing about the case, but his lawyers do, and the lawyers are qualified and they're presenting it, and you got a lot of stockholders out there. And so let him stay. He's not going to do any harm.
You mentioned his lawyer. The lead lawyer in Delaware was Bill Prickett.
Yes.
What were your impressions of Bill?
I don't know if I should say all that on camera or not, but now Bill was a very good trial lawyer. I got my experience with Bill in his office when I first started practicing law down in Dover, because back in those days, his firm did defense work for insurance companies in personal injury cases. Anytime you filed a personal injury case, within days you got a set of interrogatories and an answer from Bill Prickett's office and that sort of thing. And so I had, known him from, just not him so much, because I generally got Rod Ward or somebody in those days who would be in the case. But when it came to Chancery, then by that time he got into some of these things, and I was familiar with Bill, and he was a good litigator. He was a good litigator because he spent a lot of time in court, cross-examining witnesses. He'd been in court as a litigator. Down when it was, a case a week or something like that, defending things, which kind of makes a difference. And I mean, that's not disparaging corporate lawyers in New York who don't get in, to actually try a case that much. But he did. He was there, and he knew how to handle himself. And he was ornery. He liked to have a sense of humor, and he liked to get at things. And I was just familiar with Bill. He was a good attorney. Knew what sometimes he would have rather preposterous approaches to things, but if you called him on it, he'd back off and come another direction. But no, he was good, and he was colorful. You kind of always enjoyed Bill coming into court because you knew it wasn't going to be another dreary argument. It was going to be. Bill had I observed, he had a knack for always in court wanting to poke some kind of a jibe at the opposing attorney along the way by, little things like if my worthy opponent on the other table had read the cases that he cited in his brief, he would know that his case is absolutely unsupportable or something like that, which would cause the other attorney to get up and say, Your Honor, I've read all those cases. And, well, I observed, my observation over the years was Bill did that just as a tactic. He wasn't mean about it or anything. He just poked the jibe to get the guy off his train of thought, his opponent. His opponent was there to make an argument, probably things racing through his head that he was going to say to the court. And Bill would say something to cause him to forget all that and have to defend his honor or something. He was colorful like that.
Did you have any contact with the New York lawyer who was involved on behalf of Mr. Weinberger?
Not that I recall. I can't remember who it was.
So the case was litigated by the Prickett firm?
Yeah, yes.
You end up certifying Mr. Weinberger as a class representative, but then you cut down the class size to stockholders who hadn't voted in favor of the deal.
Yes.
What was your rationale?
The way, again, that Signal had structured the merger by giving the minority the chance to vote it down if they wanted. And Trying to think if there's anything else. I'm sorry, ask me again.
Well,
What was the class, cutting the class?
Right.
Yeah. It was like 147,000 shares or whatever that hadn't voted. The merger was overwhelmingly approved, like 12-1 by the minority. And with Signal's holdings already, it went way past the 2/3 requirement that they put as a condition for going through with a merger. So I don't know, it just seemed to me that under the circumstances, those people that were happy with the merger price, which was, I think, $7, something like $7 or $8 a share above the market price when the merger was announced, I didn't really see why they should be coming back in to maybe get more, but I thought those who voted against the merger certainly were entitled to be represented. So I thought, in my mind, the logical approach would be to make the class the people who opposed the merger, who didn't want the $21 a share, wanted something else. The rest of them are happy with $21 a share, you know.
So the proposed class had been about 5.7 million shares, and the class certification decision cut that down to 140,000 some.
Yeah, 147, I think it was, from reading it.
Did you expect the case to disappear at that point because it was no longer economical to pursue?
I don't think I did. I never paid that much attention to them. I never knew what the financial arrangements were that local council had with class representatives and that sort of thing. I don't know. It was just, I made a decision and that was it. See what happened.
At what point did you start to think this might turn out to be a really important case for Delaware law?
Prior to the Supreme Court decision, I'm not sure I ever did. It just seemed to me that it was, I only decided things as a vice chancellor based on Delaware law, precedent, statutes, argument. After 12 years, I never decided anything based on a decision of a court of out of state. And I always just, the only thing I ever cited was reported Delaware decisions. Remember, Chief Justice Herman told me one time that an unreported decision has no precedential value. You're not bound by them. A reported decision does. So I figured, well, and there were enough reported decisions out there going back in the 20s and the 30s and the 60s or something on corporate things that you could, if you read them close, tried to see what the reasoning was behind them, you could generally use the Delaware authority, reported authority, as a basis for reaching your decision. So that was my approach to things.
Did you have litigants cite to you unreported authority or things like transcript rulings to try to persuade you one way or another?
I won't say that that was never done, but it certainly wasn't predominant. An unreported decision, you're not bound by it. You may be now. I don't know what it is now. Back then, and if you wanted to cite an unreported decision as authority, the requirement of the Chief Justice was you couldn't just cite it, give the citation. You had to give some background of the facts and what the thing was and what the reasoning was for deciding. You could use an unreported decision then. But a reported decision, you have to do that. You could just cite it.
Fast forward to the trial. It's 11 days long. Was that typical of corporate cases that went to trial?
No, not mine. I never had that many actual trials of corporate cases. And they had trials in land disputes and specific performance actions and things like that, but when you get into big corporate cases, I don't remember having that many actual trials. Most everything went off on questions of law applied to facts that were before the court on summary judgment procedures and that sort of thing. It was the argument and the briefing and that sort of thing that you used them. So that may have been the longest case I ever tried, for all I know. I don't remember. I don't remember anyone being in it longer. I didn't remember that one being 11 days till I I read the decision.
Let's talk about the experts who presented their opinions at the trial. The defendants submitted a report by Mr. Purcell that applied the Delaware block method. What was that?
Well, the Delaware block method, established by reported precedent, I might add, was if you were valuing stock, you had to, there were four things you had to look at, and I forget exactly what it was: asset value, earnings, market price, and something else. And you had to look at the business of the corporation, what it did, what its future prospects were, based on the evidence presented to you, and try to put a number on each of those 3 or 4 categories. And then based on things outside the numbers of business prospects or past or whatever, you had to weight those 4 categories and come up with a number. And that gave you the value of the stock for purposes of litigation purposes, I should say. Now, that's not saying it too well. Somebody could read it and get it better, but it was along those lines. But it was established under Delaware law. Might have been established in Sterling versus Mayflower for all I know, but I had cases before, even though I hadn't been on the bench that long, corporate cases where I had to value stock and had to use it. And that's what Delaware law said you had to do.
The plaintiffs proffered Kenneth Bodenstein, who presented a premiums paid analysis and a discounted cash flow analysis.
Right.
What was your reaction to that?
Well, the premium based on comparative transactions, that wasn't to me unusual. It had that. I think that normally came in. An expert would look at other merger acquisitions, that sort of thing, similar over a period of time, and see what was paid and that sort of thing. Use the numbers, see what kind of a premium over market price was paid in those things, and use that as a basis for coming up with their expert opinion for what the stock should be worth in this case. So that wasn't necessarily new, but this thing called the discounted cash flow analysis was completely new to me. But not Prickett. Prickett was out there sallying forth. He had Mr. Bodenstein. He was a nice guy, very, very cooperative, very qualified, I'm sure, but he had this way of using the elements for a discounted cash flow to come back to a value. And I kind of thought when I was hearing all this, what in the hell is he doing? You know, I can't use this. Delaware precedent says it's a Delaware block method, and you do it this, and he's coming in with Mr. Bodenstein, who's projecting out and discounting back and all that sort of thing. But you listen to it, and when it came time for a decision, if you're there yet, it seemed to me that it not only didn't jive with precedent, but it was a little too loose for putting a value of stock at the time, or putting a value on stock as of the time of the merger. And I don't know, just the idea was that you use projections and that sort of thing, and you get a figure way out here 10 years ahead, and then you discount it back by some percentage, and that percentage comes right out of the expert's head. I mean, everything up to that point is documented by numbers and all sorts of things, everything fine, but at the end, it's a question of whether you put 4%, 8%, 6%, or whatever, which comes out of the expert's head based on his experience. And I thought, that's not the way, as I understand Delaware law, that you value stock for the purpose of a takeout of the merger.
So I take it you didn't expect the discounted cash flow methodology to catch fire in Delaware jurisprudence?
Well, never thought about it, to tell you the truth, but I think not, because based on precedents and other cases that I had, I thought this is so far out beyond what Delaware law says. I can't imagine anybody's going to buy that. I'm certainly not in a position at the trial court level in view of precedent to say that I accept, and I'm going to establish new law. I try never to establish new law. I always just tried to follow what the law was. And I remember Justice McNeely one time told me when he was a judge on the Superior Court down in Sussex County, he used to have to sit in Wilmington every once in a while and handle motions. And he'd hear argument on the motions, and he said he just ruled from the bench. Motion granted, motion denied. He said, and Wilmington judges, he said, they want to write decisions and write opinions and all that sort of thing. He said, Superior Court doesn't make law or write that. That's for the Supreme Court. Someone wants to know why they do something, take it to the Supreme Court. He just said granted or denied. So, in any event, it's you know, I didn't know that didn't expect anything to come out of it one way or the other. I never ran that deep. I was just handling what was in front of me.
It must have been a huge risk for Bill Prickett to present an expert who didn't use the Delaware block method at a trial in a big corporate case.
He gambled.
It seems like a huge gamble.
Yeah. Like I said, when we was putting this on, I thought, you know, why is he doing this? I can't use this. As I said, it's not the law. There's a way you do it. It's established. I'm bound by it. I'm a trial court. But I didn't like the logic of it either, because it seemed to me there was something a little loose there at the end.
Did you have the sense that he was trying the case to take an appeal, or?
No. I'd say I never ran that deep. I just figured this is the case before me, this is what he's offering. I'm not sure why he's doing it. I suppose Bill thinks that maybe I'm dumb enough to buy it. But
You weren't.
well, I wasn't on that one.
On February 8th, 1981, you issue a 79-page post-trial opinion.
I did that, I have to confess.
That seems long.
I'm sorry about it, but I did it.
Was that typical?
Not back then, no, not. I don't know how it came out that long. I don't think it, well, I guess it's 79 pages, you've measured it, but it was a big case. It had gone on for a long time and years, and there was things in it, and I was trying to, I think, put everything. I figured it was going to be appealed at that point. Anything that big, you know, is going to be appealed one way or the other. And I was just trying to make a thorough presentation of why I did what I did. I always tried to do that. I suppose I was accused early on of writing opinions that were too long, back when Bill Quillen was chancellor and he got after me, and I was vice chancellor. He said, your opinions are too long, you got to cut them down, because they would run 20, 22 pages or so, double space on a typewriter. And he said, it's not good. And I told him, I said, Bill, well, the reason I do that is I try and put enough in the opinion, facts and law, so that if the Supreme Court says I'm wrong and wants to reverse, that's fine. They can reverse and enter another judgment. But what I don't want them to do, which I had seen them do quite often, is send it back, remand it for further proceedings, because they didn't have enough to go on. I said that was my approach to things. I didn't necessarily want to write long opinions, but I wanted to put enough in there so that if the Supreme Court said I was wrong, they could reverse it and say enter judgment accordingly. Don't send it back for 6 more days of trial or something. And I think probably that's what I was doing in this case, but it got out of control because there were so many things in it.
The Arledjan-Chaitia report plays a huge role in the appeal. It appears just once in the post-trial opinion in the background section. Did it play a big role in the trial?
No. Absolutely not. I mean, it just wasn't brought. It was in evidence. I think it was obviously it was in evidence. It was a document, but there wasn't any big discussion about it. It certainly didn't take on the importance. Took on no importance, quite frankly, at the trial. Nobody made any kind of an argument that was anywhere near what the Supreme Court found when it reversed. As a matter of fact, I think one of my later decisions reviewed for the purpose of this interview indicated that neither Arledge nor Chaitia testified in the trial. They weren't called as witnesses. They were on the witness list. Could have been called. They didn't. They weren't there. And I think somebody pointed out that Mr. Bodenstein, the expert witness for Bill Prickett trying to establish value and all, he was on the stand for the better part of 3 days, and he only mentioned it once, the Arledge and Chaitia report. And it just never was anything there presented about Arledge and Chaitia. They didn't appear. The report wasn't. It was mentioned or something, maybe in a post-trial brief. I don't know, but it was not the big thing.
Did you expect the appeal to turn on that issue or other issues?
Well, I certainly didn't expect it to turn on that one. It never entered my mind. I mean, I understand the reasoning of the Supreme Court, but it seemed to me it was a stretch for the Supreme Court to attach that much significance to the Arledge and Chaitia report to get to a result. I think the Supreme Court, just on reflection years later, the Supreme Court needed to do something, and they needed a vehicle to do it, to make some new law or clarify some law, as the case may be, or both. And but they had to find a way to reverse. And I mean, I don't know that they could have affirmed and put out an opinion that clarified everything and did all the things that they did in the decision that came out. And it was there, and Justice Moore wrote a very good opinion, and he got the mileage out of it. But it really wasn't in the case at the trial level. And what was I can't remember now, but I'm not even sure the Signal board of directors ever saw it. I know in one of the follow-up decisions I had to make, it was, the argument kind of went that, if I can remember it right now, that the Arledge and Chaitia report was prepared by Signal, and somehow it was assumed, based on the Supreme Court's decision, I think, that the Signal board of directors considered it in deciding to go through with a merger. There wasn't any evidence of that, that I recall. I don't think the Supreme Court found any. It just wasn't there. But the fact that it was there, and it was a Signal document that reflected on at what prices an acquisition of the minority of UOP would be beneficial to Signal. It had a lot of good stuff in there to use if you wanted to say it's a document that should have been disclosed to the shareholders, minority shareholders. Well, I never thought it was anything more than what it was offered to be. It was somewhere along the line, Arledge and Chaitia were members of Signal's management. They were vice president each of something, I don't know which. They were also on Signal's board, and they were also on UOP's board. And the inference was somehow from now all of that Signal's board had to be aware of this and would have considered that at any price between $18 and whatever it was, $24 a share, would have been beneficial to Signal, good investment for its money. And I just want any proof anybody considered that, but the Supreme Court said, well, it was there. And somehow the minority shareholders, I guess, should have been made aware of the fact, even if nobody at Signal's board considered it or UOP's board considered it, the minority shareholders should have been made aware of the fact that there had been an analysis made by Signal management personnel, just for informational purposes, I think, that said you could pay up to $24.
I want to go back in time a little bit to what I would describe as appellate decision number one, which is the affirmance of your 79-page post-trial opinion,
Oh yeah, I forgot that.
Justice Duffy, Justice McNeely, Justice Quillen are the decision makers, and they affirm.
Yes. I had forgotten that. It was refreshing to find out that I did get affirmed somewhere along the line.
With a dissent from
Yeah.
Justice Duffy. Were dissents rare?
I think so. I think you could say that back then. Occasionally there'd be one.
At this point, at the time of the affirmance, did you recognize that this was going to be a big case, or was it still just any other case?
At that point, just any other case. I had given a thorough, documented, windy, reasoned decision, and it was affirmed 2-1. And Justice Duffy, in his dissent, he didn't like the way I did a couple of things, but his main dissent was, I think, had to do with Lehman Brothers, wasn't it? That I kind of threw. Lehman Brothers was a financial advisor that had put the blessing on the price of the merger and all. And he thought they should have had some fiduciary duty, and I wasn't aware that the financial experts had any fiduciary duty. So he would have reversed on that. But he also said he thought, I think that somehow I put the burden on the plaintiff to show the price was unfair, when really, under established law, and particularly under Singer, I suppose, the burden would have been on Signal to prove the fairness of the price.
So,
I mean, I can add my personal view is I can, knowing Justice Quillen and Justice McNeely, whom I knew both very well for a long time, I'm sure they took one look at 79 pages and all this stuff and said, we're not going to mess with that. He's got enough there. It's a reasoned decision. We'll affirm. I'm sure that's how it came about.
did you expect the case to end after the affirmance?
Well, no, because the Supreme Court in its decision sent it back, going to remand it to have me decide what damages, if any, the class, which had then been expanded by the decision to include all the 49% minority shareholders, not just 147,000 shares that I had, but the 5 or 6 million shares.
Well, I want to focus you on the fact that there was a petition for rehearing filed by the Prickett firm. It seems as if it was a Hail Mary. They lost at the trial court level in a 79-page opinion. The Supreme Court had affirmed with one dissent, and yet there's a petition for rehearing. The persistence is stunning.
Yeah, I didn't know anything about that time. At that time, I didn't know what proceedings were going on in front of the Supreme Court. I didn't know anything about a petition for rehearing or whatever. I'm not surprised, knowing Bill. He would have thought, Lord, what will I put into this case? And I get this kind of decision, I think if they granted a rehearing, it had to be by the court en banc. Wasn't that true? That you had all 5 members. So he's basically drawing a new hand, like in poker. Give me 2 new cards.
And I want to focus on that because it does appear that he did, in fact, draw a new hand, because the decision, the next appellate decision, is by a court that is totally different.
Yes.
Because Chief Justice Herman is a decision maker. Justice Moore is on the court at that point. Justice Duffy has retired.
Mm-hmm. Yes. And Justice Horsey got on it somehow. I'm not sure why he wasn't on it the first go around. Seemed to me it had something about the time he'd been on the court or something, but because the opinion of the firm had pointed out that Quillen, Duffy, and McNeely were the only members of the court available or qualified or something at the time to make the decision. And I think I picked up in watching Gil Sparks' interview, which I didn't remember, that Herman got back in because in the case Lehman Brothers was, as a financial expert blessing the merger, was represented by Richard Slayton, and Chief Justice Herman's son was a lawyer, partner at Richard Slayton, so he wouldn't sit on cases where his son was in. But I think Prickett dismissed Lehman Brothers, didn't he? After took them out of the case, so that was a rather smart move in the long run. And I didn't think he had a case against him anyway. I think he just threw that in there to see what he could get. And so he dismissed him. That freed up Herman, so he could be on the court in Bonk. And then whatever the time limit was on Horsey serving, that expired, so he was on.
So, does, at least from reading the opinions, it seems as if the tenor of and the Supreme Court, or the tone at the Supreme Court, is totally different between the decision affirming you and then the decision reversing. What happened?
I have no idea what happened. I think because I think it had to do with Justice Moore. He, as I say, I think he wrote a very good opinion, but it looked like they decided somebody got, probably Moore would be my guess, whom I knew reasonably well over the years. Somebody thought, we got a problem here with Delaware law. We got to get some things straightened out for the good of the corporate bar and the state's image and everything else. And this is something that's laying here that we can pick up and use on this re-argument to do that. And so, to me, that's how it came about, because, you know, they did certain things in there. They did away with the Singer decision, and those that followed it, theretofore said you had to have a business purpose if you were the majority. You just couldn't use your 51 or 52% majority and merge out, cash out, particularly cash out. Might have been different if you were, you know, merging and giving them stock in a subsidiary corporation or something, or some kind of stock. But you couldn't just cash them out, you know, without a business purpose. And in the process, the Supreme Court, as newly constituted on the rehearing argument, decided that's no longer the law in Delaware. You don't need that anymore, because they opted for the entire fairness standard, I guess. I think it came to light most notably in Sterling versus Mayflower Hotel Corporation. As long as you got the entire fairness test and that sort of thing, you don't really need this business purpose. So that was one thing they got rid of. And they also established, I'm not quite sure I ever fully understood, but they quite established a new way of valuing them for appraisal actions and that sort of thing, which basically said you just got to look at everything. Under anything that the, you know, market's using, you know, and they said something about an appraisal action henceforth would be the way you take care of these things when you have this kind of a situation for the minority shareholders, which I don't think ever really proved out. But it seemed to be an instructional decision on 4 or 5 things, 3 or 4 things, to in effect say this is a law going forward. The Delaware block method is no longer there. You can use anything that's acceptable. You don't have to have a business purpose anymore, but you do have to measure things by entire fairness, and you know. And actually, I did get affirmed on a couple things in there, whether you noticed or not, because in the court below, there was a question about burden of proof and that sort of thing. And how did it go? I think I said, well, for this business purpose thing, you can't just allege that. You got to have, if you're going to put the burden on the majority shareholder to do that, you got to allege something that they did wrong, because this is not an administrative hearing. This is a court proceeding. You got to have evidence, and there was something else in there. I don't know, but in any event, the Supreme Court pointed out that I'd made a couple decisions, and right in the opening paragraph or second paragraph said we affirmed the chancellor on that, and there was something else they said I did that they approved. So it was nice. I got 2 little things out of that.
So at this point, I take it you realized the case was going to be big for Delaware law.
Well, I don't know that I did. I mean, I didn't appreciate it at the time like I do now, for instance, because we had other things to do. Who cares? You know, it's up, it's gone. You've done the best you can. The Supreme Court reversed. It's coming back. Meantime, I get hammer mesh, and everybody's in with all other cases, and you got things to do. You don't really sit back like an academic, and like you're an academic, you get to reflect on what's going to happen now. You're just trying to keep up with what you got back in those days.
Do you recall there being a reaction in the corporate bar to the decision in Weinberger?
I think there was. I think I picked up something about that. The corporate bar wasn't necessarily happy. Maybe some of them were. I'm sure Prickett was. but yeah, I think it was new. It was novel, and I'm sure there was innumerable law review articles written about it. I never read law review articles, so they were beyond me.
In fact, Bill Prickett wrote a law review article shortly after the opinion discussing some of the takeaways from it. But I take it if you didn't read them, you weren't paying much attention to what was appearing in the Delaware Journal of Corporate Law, or...
No, unlike modern jurists, I wasn't an academic by nature. You know, I didn't go to Yale or Harvard or anything, and hell, I couldn't have got into Harvard as a janitor. But, you know, well, what should I say? Let it go with that. I'm just saying, and I don't mean to be belaboring this, but the court was busy back in those days. We had a lot of things going on daily, and the last 3 years after I was appointed chancellor, I worked 3 years, never took a vacation. I never took a day off. I even had to come to Wilmington a couple times on Sundays for labor disputes and that sort of thing. You just didn't have the time to sit down and engage in academic, you know, thoughts and analysis, particularly since you don't have the mind for it. And so I never did that sort of thing. Try to keep up, survive. Survival's the name of the game, you know.
One more question before we leave the appellate decision. Justice Quillen and Justice McNeely had been on the opinion affirming you.
Yes.
They also sign on to the opinion reversing and remanding. Did you ever learn how it was possible that they could be on both sides of this issue, quite like they were?
No, I never learned. I just, you know, presumed they became enlightened. I think I thought somebody. That's why I kind of blamed Drew on it, I guess, because I thought somebody caused them to see a different perspective on things. And I don't really, as I said, I doubt they put a lot of time in on that first decision, just because of the way it was. It was on facts. It was a lot of facts. It was 70 pages long, and you know, I had an analysis in there of whether the Singer case affected something, all that sort of stuff that they didn't really need to put a lot of time into. I'm sure they had other things to do too. You know, we were all busy in those days. But my guess is, without knowing, I thought when Justice Moore got in there, he's a fresh voice on the court. And he probably, knowing Drew, he sat him down and said, look, we got to do something about this. And this is a case to do it in, and here's the points we have to make, 1, 2, 3, and they agreed.
So the case comes back to you.
And the thing you never want to happen, but it came back.
With and the Delaware block method has been declared outmoded, and instead there's a new valuation standard.
It wasn't done away with. You could still use it, but it wasn't the exclusive. I think it was the way it came out. Theretofore, the Delaware block method was what you used. And they said, well, it's no longer exclusive. You can value by any means that's acceptable and bona fide or whatever.
And the court also indicated that rescission or rescissory damages should be on the table as a remedial tool.
Yeah.
How did you deal with this seemingly big change in the law?
I guess at the time I didn't have to do anything. I had to wait till something else came in before I was compelled to do something about it. And what did I have? I had two or three decisions I had to write after the Supreme Court decision, as I recall.
The parties, or at least the defendants, asked for a preliminary hearing on
Rescissory damage.
and essentially what to present to you at the trial on damages.
Yeah, the defendants, that's right, the defendants, they were concerned. I seem to remember vaguely after the decision, all the counsel coming into chambers one time shortly after it, and somebody, I think it was Alan Halkett, the attorney from Latham and Watkins out in Los Angeles, said, "Your Honor, what do we do now?" And I said, "I don't know. We'll have to work on it," something like that. They didn't know how to proceed as a result of the Supreme Court's decision. It had been remanded back, and there was stuff in there about rescissory damages and obviously some other things, and they were, been remanded. How do we set up the remand? What do we do? So we figured out whatever came to pass, I guess, but that was the initial reaction.
It raised, at a minimum, a big discovery issue, which was what to do about the changes in the business since the closing of the merger and how to put the parties in a position to present evidence on what rescissory damages should look like. How did you approach that?
Well, I was asked to rule rescissory damages out of the case on remand. That was the application, for the reasons you just gave. This is going to be a mess if you're in the rescissory damages. The merger's been over for years. We got to go back and get more discovery from years going back. We got all sorts of expense. Things are piling up, and if it's not a really rescissory damages case, you ought to get it out now. And I think I don't really know how I can do that. The Supreme Court has kind of sent it back, and I guess they said rescissory damages if found appropriate or something. But I think at the time, I'm not even sure I recognized what rescissory damages were supposed to be or how you got to them. I'm not sure I could explain it now, but it's like if the merger was wrongful and shouldn't be upheld and should be undone, if you rescinded it, you would put people back to where they were before the merger, stockholders. Well, you couldn't do that because time had passed, years, and so you would have had to work out somehow a value somewhere in between in those years, pick a date, and from whatever the reasons you can accumulate, but say as of this date, if this merger had not occurred, I guess I should be better. Merger had not occurred, and these people still had their stock. What would it be worth then? And then you would take that number and deduct the $21 a share from it, and that's how you would get the rescissory damages. The theory being we can't give them their stock back. If we could, their stock would be worth whatever you find the value to be on the evidence at a point in between in those years. But since we can't, give them the stock back, we'd have to give them the value of the stock if they still had it. It was kind of a mess.
It makes a discounted cash flow analysis seem easy.
Yes, it gave it an appeal. Anyway, they asked me to rule rescissory damages out, and I said I can't do it at this point. I think probably because I didn't know enough about what everybody was talking about. And since the Supreme Court had suggested, if warranted, rescissory damages, I didn't, having been reversed once, big time, I didn't think it was appropriate to get rescissory damages out ahead of it. I could see where they were coming from. They didn't want to have to go to the trouble. They didn't want to have to go to the expense and that sort of thing. But trouble and expense hadn't been any problem for 4 or 5 years or whatever this has been going on. So we'll just do it a little more. And I did say I'm not going to award rescissory damages, but I'll wait till we get. Go get what you want, bring it in, and we'll decide whether rescissory damages are warranted or not. So I declined the motion.
At this point, are you expecting the case to settle, or do you think this one's going to the bitter end?
I don't know. I don't remember. I'm sure I was hopeful it would settle after having spent all this time in it. But I don't really have any recollection one way or the other.
So
It didn't, quite frankly, it didn't sound like it was going to settle, because it just wasn't Bill Prickett's nature to want to kind of give up for something less. He's, if he thought he had a big hit out there, and he just had a big Supreme Court decision, and he did a great job. He, like you say, he got a new hand, he got a new panel, he got a new decision that changed the law all around, and also got the class expanded from 147,000 to 5 million or whatever. And, Bill's a gambler. That was worth taking a shot at.
So the damages trial goes forward,
Yes.
and the opinion on the damages trial gets issued in January 1985. It seems as if you're as uncomfortable with rescissory damages as you were with the discounted cash flow analysis. But then you award damages anyway. How
Well,
did that come about?
I just assumed as a practical matter from the Supreme Court decision, they held that the minority shareholders had been wronged, and sent it back on a remand. And I said, well, if I just haul off and say no damages, going back up on appeal again, and they ain't gonna put up with that, I don't think. So, and the case has been going on long enough. I thought that on this remand, as I interpreted, some award of damages is expected. I got to come up with something by way of damages to get this thing over with. But to come up with something for damages, I got to find something I can justify. I can't just pick a number out of the air. I mean, you sat around there and thought, maybe I'd give them $3 or $4 a share or something like that. But hell, there ain't any way I could justify it on the evidence. I didn't have any basis for saying $5, $10, or anything else. Well, I thought I had to come up with some kind of damage, so I'm probably anticipating a question of yours, but I thought, let me root around in the evidence and see what's in there that I can work with. And I know, I'm sure Bill was greatly distraught to get $1 a share, but there was something in there. I think who was it, the Dillon Reed guy?
Mr. Purcell.
Mr. Purcell, and early on, before the merger and some of his things, he had pointed out that for Signal, that paying up to either $21 or $22 a share would be all right. So I said, well, we got Signal's expert that way back before all this mess started said it would be all right, fair to the shareholders and fair to Signal, to pay $22. They paid $21. That's $1. At least I got something to go on. And there's 5.5 million shares out there, and that's not insignificant to me. It's $5.5 million. I mean, it's insignificant to Bill. He was probably wanting 50 million, but I wasn't really concerned about him at that time, as much as I liked him. But so anyway, I figure I got to come up with something to end this. And what have I got in front of me on remand? They came in with the rescissory damages nonsense, and I couldn't buy that. It was just too speculative as far as I was concerned. I think in the Supreme Court opinion it said something, there was something, the word speculative was in there. You can award damages as long as they weren't speculative or something. So. But this idea of having to try and figure out what a share of stock would be worth at some point, but you didn't know what point. How'd that go? I think the experts, what was it? You can help me out on this because but you had to use a date. And they used a date that was, the end of a year, whatever it was, but they picked a date because it was the closest or something to the date of the Supreme Court's decision, and it was closest to something else, I can't remember what. So how in the hell do you get anything logically justifiable? That's all I could work with. I mean, I'm not faulting them, but there wasn't anything you could get to, so they're basically saying, well, Your Honor, you're going to have to pick a date somewhere between this point and this point as to what the stock would have been worth if it hadn't been a merger. Now, to get to that point, we got to use the end of December of this year and the end of December in that year because they're closest to a Supreme Court decision. And, you know, how in the hell do you put all that together to get the value of stock on a certain date? It was beyond me. It would have taken somebody with more academic ability than me to get to that.
I take it that after you issued the January 1985 ruling in damages, you expected the case to stop. But then there's another appeal.
No, I didn't. I didn't necessarily expect it to stop. I mean, I figured, knowing Bill, he'd try it again, but I didn't know what else I could do. It had been remanded. I'd done the best I could again, interpreted the Supreme Court, what they said, what I was supposed to do. I looked at the evidence. I tried to find some way to logically justify a result of some damages because I thought that was implicit in what the Supreme Court sent back, and that was the best I could do, you know.
There's an appeal. Signal files a motion to affirm, and the Delaware Supreme Court grants it. And so the case is finally over.
Yeah, I didn't remember that. I learned that in part of this exercise.
You must have been relieved.
Yes. after all that. I didn't, you know, it's a very interesting thing now to go back through all this. It wasn't terribly fun back in those days with everything else you had to do to, what, Weinberger's here again, you know? And, but looking back, it was a good exercise, I think, in the Delaware judiciary, trying to make sure that its corporate law was up to date with what was going on. And like I say, I never mind being reversed. I just didn't want them to send it back, but I lost on that. But
you won the second time.
Yeah, I did get 50%'s not bad, I guess, on a case like this. I didn't know it was going to be this big of a thing when it started, and I guess I probably didn't realize it was this big a thing until you got me into this. But
well, thank you very much for sharing your thoughts today.